chartered accountant details shall be given to the banker, wherein banker will update this information in their software or the application, and for subsequent withdrawal, banker expect the professional certificate from the same professionals whose details are given at the time of opening the bank account. Friends, I heard from the few bankers that even they will implement the existing accounts also by sending the necessary communication or required information to all the RERA project bank accounts. Maybe when you go to the next time to any of your bank, the banker may ask you to provide these professional certificate details, wherein they will maintain the database of those professionals project wise, and subsequent withdrawals are permitted to obtain the certificate from these professionals, chartered accountant, architect, engineers. If somebody willing to or need some more information, you can contact our team. They are more than happy to share the circulars or maybe the details relating to this. And today's topic of the defect liability, even though the topic is more relevant or more insightful for the architects, engineer, or the operation team. However, given the requirement for everyone to aware and understand how it impacts, so me and Suhail both are presenting in the interest of the promoters and the stakeholders. So first, let us look at what is the structural defect liability and overview. Basically, if you say defect, forget about defect liability. First, let us understand what is the defect. So when the moment we say it's a defect, it may be with the multiple reasons. There may be inherent product defect itself due to the material, or it may be the workmanship. Because of the workmanship, there may be a defect, which amounting to the defect either in the product or in the services. So that will lead to a complaint, or that would be escalation by the customers in the project. So there can be a patent defect, there can be a latent defects, like something which we call it as a patent defects by normal examination. Maybe you may look at that there may be a leakage in the roof, or there may be some foundation crack, which can be on the face of it, you can discover it. But few of the things which cannot be discoverable by the naked eye, that may require little more examination by way of testing. Say maybe in terms of the concrete, a cube testing we call it as. So that may be the one of the tests that can be conducted to check the quality or deficiency in the workmanship of the material. So this is what is the something which is general defect we call it as. And this may be a design error by the architect or maybe by the engineer in terms of the structural quality, or in terms of the mixing, in terms of the improper installation of the materials, or maybe a combination of all these things which may lead to a defect in either the structure or otherwise. And the moment we call it as a structural defect, because a defect liability talks about structural defect under RERA, and also it goes on says various other defects. In the subsequent slide, we'll go through and understand what all included as a part of this defect under RERA. Friends, keep it in the mind, even though it looks very big, the moment we say it's a defect liability and it covers for 5 years, one need not to panic. One need not to panic about this 5 years and about this defect liability. It is not just somebody send a mail stating that there is a defect in this product, defect in this wall, defect in this roof, defect in the tiles and the doors. You should come and replace it, or come and attend to it. It may not be as simple as that, somebody to raise this query. And however, this need little more caution, little more process, little more procedure for any promoter to accept this and also react or reply to the defects communication by the customer section. Suhail, if you want to say anything before we proceed.
No, not at the moment, Vinay. You can take it forward. I will come in later.
Sure. And let us look at the exact provision under RERA on the defect level. On the screen, you can see that like this is what exactly the provision of RERA in terms of the defect. In case of any structural defect, you have to refer to the section 14 and bracket 3, subsection 3 of RERA, where you have to check that in case of any structural defect or any other defect. First, you should remember there is a structural defect or any other defect in workmanship, quality, or provision of services or any other obligations of the promoter as per the agreement for sale relating to such development is brought to the notice of the promoter when within a period of 5 years by the allottee from the date of handing over possession. Friends, the red colored texts are important for us to understand what is this provision, how it affects, how it impacts, how do we address as a promoter, how do we address as a professionals in case of any of such complaint, any of such concern, any of such escalation by the allottees of the project. In case of any structural defect or any other defect, that is the first one. The moment we call it as a structural defect, generally the word structure is referred to any of the construction. It may be a wall, it may be a roof, or it may be a beam, it may be a pillar, or whatever may be. Okay. So this structure. So generally, to what extent, to how the structural defect will be identified or would be communicated is important. Generally, the tendency of the customer, tendency of the allottees are restricted to his apartment or his house, which he has bought it. At the big picture, the association of allottees or the group of allottees in the project may come to a promoter to state that, say, there is some structural defect in the common area, which may include in the parking area, which may be included in the terrace area, or which may be included in the common pillar beam. So first we should differentiate something which is inside the home, which directly impact the allottee. Second is in terms of the common areas in the project, which may include the clubhouse also, which may include your swimming pool also, which may include your overhead tank also. So these are all the common area which everybody or all together enjoys in the project. Everything comes under the purview of a structural defect. So what is the structural, what is part of the structural defect is either, as I mentioned, it's a quality of the material which are used or the workmanship. That means to say the labor or the quality of the material which are used, which is combination or maybe the combination of these two will lead to some of the defect. Okay, some of the defect in the project and or any other obligation of the promoter. Generally, there is no specifically has mentioned what is any other obligations of the promoter. When something which is mentioned as any other obligations of the promoter, it should read with the in relation to what we are discussing. So what are we discussing is in terms of the structure or defect. So any other obligation related to the defect is only to be part of this section, not like any other obligation should not be read in any other manner. So first is about the quality, second is about the provision of services, and the workmanship combined either individually or collectively may lead or result into defect in the either the structure or otherwise. Maybe when I say structure or otherwise may include the your what may include your any other in the structure. It may be a wall, it may be your door, it may be your roof, it may be your tiles, it may be a plumbing line, it may be a mechanical, it may be electrical, or it may be a common area, or maybe at the grand entrance if something which you have a gate, the gate which has something which is related to the defect, those things are all included as part of this defect. So in terms of that, so which again refer back to the agreement. Friends, anything we talk about which has a reference either the agreement or maybe by looking at their marketing collateral or promotional collaterals. Something which is not part of any of these things, it is very difficult for somebody to come back and say that these are the defects relating to that. So first we should look at that, what is a defect, and whether those things are part of your agreement of sale. And if those things are brought to the notice of the promoter by the allottee, when within 5 years from the date of handing over of possession. So we should see that within 5 year period of 5 years by the allotee from the date of handing over of possession. If you say that by the allotee is only mentioned, it is not mentioned by the association. So by looking at that by the allotee from the date of association, allotee has a right, allotee has something related to his house. Of course, he has a common area also. So in relation to that, he can bring which related to the common area also. So from the date of 5 years from the date of handing over of the possession. So handing over of the possession is again something which we should see that. Say an example, handing over the possession, maybe multiple thing, like somebody may hand over the possession for the purpose of interior work, somebody hand over possession only after the sale deed. So which date should be considered for the purpose of RERA to consider these 5 years? Suhail, can you add something here based on your experience, like the 5 years start from what does that mean, the handing over of the possession, or anything related to this slide? Please add your inputs.
Okay, so primarily, if you see, defect liability can also be read along with the right to sue a promoter under section 14. That is, if by filing a complaint under section 31 and seeking compensation. So for adjudication of compensation, what needs to be proved is by virtue of this defect, if there is a structural defect and structural or any other defect as defined here, if it is brought to the notice of the promoter and the promoter does not rectify the defect, then in such case, the allotee, either for having sustained loss for whatever has happened, or if the allotee himself or herself remedies the defect and corrects it, the compensation that would then accrue to be paid to the allotee will be the amount that is spent by the allotee in getting the work done and then following up with the promoter and then the litigation cost. Now, when does the allotee become eligible to claim for this? Now, one is a notice has to be given that there is a defect, and that notice can be given within 5 years from the date of the possession given to the allotee. So legally, the possession in relation to a real estate project, the possession cannot be delivered under an agreement for sale. It can only be delivered under the sale deed. So to strictly read, handing over of possession can be read as on the date on which the sale deed in respect of the plot, apartment or villa or row house is executed in favor of the allotee, that should be reckoned as the date of handing over of possession. So from that date, 5 years from that date, this defect liability would apply. So in effect, the date of possession is the date of the execution of sale deed. So the allotee can then seek to remedy any defects in the structure or any other defects in the workmanship, quality of provision services for that time. Yes, Vinay.
Yeah, thank you, Sudhir. So, if at all, if there is a communication, as Sudhir mentioned, if the allotee communicated to the promoter stating that there is a defect which required to be rectified or corrected, then what is that the promoter should do it? If the promoter agreed that this defect is due to the workmanship or it's due to the quality which you have supplied, which has the uh, direct impact on this defect, then it is the duty and it is a responsibility and obligation of the promoter to rectify that within 30 days from within 30 days from the date of that communication from the allotee in the project. So remember, rectify such defect without any further charge. That's what is mentioned. Like there should not be any consideration, any levy from the by the promoter to the allottees to rectify those defects. And such defects should be done within 30 days. And in the event that failure to rectify those defects, the aggrieved allottee shall be entitled to receive the appropriate compensation in the manner as provided under this Act. So again, the moment compensation, section 19, section 18 comes into picture, and accordingly the adjudicating officer will hear this and adjudge the compensation appropriately. So first, remember that there should be
Sir,
a communication. Yeah.
sir, sorry to interrupt, sir. Your volume is extremely low, actually.
Okay, let me try. Is that better now?
Yeah, sir. It is better now.
Okay, fine then. Maybe due to the earphone. Okay. So the within 30 days from the date of such communication should be addressed and should be rectified by the promoter. So this is what is the provision of RERA. RERA talks only about this para. Section 14.3 of RERA talks about this defect liability, and based on this, the promoter and also professionals should prepare a standard SOP and also a procedure how to address this, how to communicate, how to channelize, and how to rectify this, and having rectified, what is next to be also be part of it. Say an example, somebody has communicated there is a defect. Having communicated, the promoter may check is this defect is due to the reasons which is due to the material quality or maybe due to the workmanship. If those things too are qualified and it is the obligation of the promoter to rectify those defects, then he can do the rectification, and having rectified within 30 days should communicate back to the allottee in the project rectified appropriately and accordingly. So this is the procedure one has to keep it in mind and implement in the project. So in furtherance of that, as I mentioned, these are the things which in summary, one is the workmanship, quality or provision of services. Workmanship basically in terms of the labor which carrying out the work in the project. The quality may be relating to the material. Provision of services which may be including the professional involvement in terms of the delivery of that service is all collectively resulting into structural defect or any other defect. It need not to be a structural defect, it may be any other defect in this. Is the summary of this section 14.3 of the RERA Act. Sujay?
Yes, Vinay.
You want
So
to-
the other important aspect about defect liability one has to understand as a promoter or as an allottee would be that as a promoter, um, of course, having adhered to the standard of constructions and also making sure that the construction is as per the specifications that are given in the brochure, in the agreement for sale, or any other document. Once that is done, care has to be taken in terms of keeping all the documents which are relevant, be it the lab test reports or be it the purchase orders or the warranties that the manufacturers offer, which in some cases do extend for the period of 5 years. So making sure that these documents are retained in the unlikely event of any claim being made by the allottee. So these documents will come to your assistance in terms of defending such a claim, to say that what is being constructed is as per the specifications and you have met the requirement scientifically to make sure that the materials used are proper and the quality of materials that is used is also proper, and that all possible tests, be it the soil test, be it the stress test for the concrete or whatever it is. So if you retain these documents properly throughout the life cycle of the project that is constructed, then it will be easy for you to defend any claim that is made, which either is vague, or if it is a true claim that is being made, and if you know that it is a defect, it is an inherent defect. As a promoter, we would advise that please rectify that defect free of cost as required under the Act. if it is not a defect, inherent defect, and or defect due to workmanship or the material that you have used, then the obligation or the burden to prove that it is a defect would then shift to the allottee, because merely sending a notice would not prove that there is a defect. So a defect, of course, if we go back to the Consumer Protection Act and borrow from there, any defect has to be proven scientifically. So which means that if I say that this is a defect, let's say that I say that there is a structural defect, or let's say that an allegation is made that a particular area of the, or some tiles, be it in the bathroom or something, are not laid properly, the waterproofing is not done properly, it should be scientifically proven, that is with the help of a certificate by a professional to say that this is not normal, because there are certain things which are normal, which is also due to wear and tear, which is also due to the normal air cracks that happen, or the environment. There are so many things that are attributable to things which are not defects. So when that is the case, then the allottee would necessarily have to prove that it is a defect, and that also should be scientifically proven. So when a promoter is defending a claim under this defect liability, the promoter will have to make sure that it is defended properly right from the beginning. It's not at a later stage that you can correct whatever you are placing on record if you are facing a complaint under section 14, be it for compensation or anything else. So it should be done right at the first go, that everything has to be done properly and it has to be done as per law. And in order to make sure that, one, if it is proper that what you have done, then to defend it accordingly. And two, if it is for a compensation, let's say that an allottee has spent some money, then you should be able to prove that that money could not have been spent, because compensation, if you know that compensation is now to be adjudicated by the adjudicating officer, where mostly the legal requirements will be adhered to. It is not very summary in nature, that is the proceedings before the authority could be very brief and summary. But when it comes to adjudication of compensation, it will be a slightly detailed proceedings following some bit of legal procedures.
Maybe subsequent slides of various states will give some idea about the some of the exclusions or some of the brief about this. We'll go through that. Then again, we'll come back to the provisions and also practices. See, if you see the Telangana Agreement of Sale or Telangana rules itself, okay, so they defend and the defect liability as, because they have excluded various aspects from the defect liability. If you see that Telangana has excluded these things, because equipments, lift, generator, motors, STP, transformers, gym equipment, which carry manufacturer's guarantee for a limited period. Friends, let us understand that most of these equipments and the materials which has a manufacturer guarantee. Say an example, I purchase a Philips item, Philips equipment. Philips equipment come with a 2 years of manufacturer warranty, and something which is of within 2 years, if something goes, it's covered under warranty period. And one cannot come back after 5 years or after 4 years stating that there is a defect in the product. If something which is a defect in the product, where there is a manufacturer or where there is a supplier guarantee or warranty is there, again it will go back to the supplier warranty or a guarantee. Next, fittings related to plumbing, sanitary, electrical hardware, etc., having natural wear and tear. Friends, let us look at that. Natural wear and tear is common, and those things are not part of the defect itself. Obviously, it's one is understood that normal wear and tear cannot be called as a defect at all point of time. Next, allowable structural and other deformations, including expansion quotient. Possibly, the professionals will appreciate and explain better rather than us. there would be always there is an expansion quotient or a joint which is prone to the leakage or prone to crack because of the weather changes. Say an example in the state of Delhi. Both are extreme. Cold is extreme, hot is extreme. Obviously, there will be a more prone to sometime of the expansion, sometime in terms of the congestion also. So considering that, that would be considered as a normal based on the climatic condition. So that should also be considered while somebody call it as a defect. And terms of work like painting, which are subject to wear and tear, one cannot say that painting and is something which is of a defect. Of course, so the same thing can be called as a defect if the quality or the workmanship which they have promised in terms of the agreement of sale, which is not used. Say an example, somebody has put some XYZ paint and which is of A quality, and wherein they have put the ABC brand with the Y quality, and if that found into a defect that ends with something the peeling of that paint and also the damage to the walls, one can pull and one can escalate it to the promoter stating that this is what is promised and this is what you have provided. That may be the reason for this defect. Of course, certain subject to the wear and tear aspects of it. This is what Telangana rules are specifically mentioned. What is not defect? What is not covered for the purpose of defect liability under RERA? Similarly, we have the Haryana state also. This is Haryana state also mentioned. The defect is not, these are all not considered as a defect for the purpose of RERA. Okay, actual physical damages are defect to the designated load-bearing elements of the building, apartment, or unit, like faults, breakages, cracks appearing over time in elements such as load-bearing columns, beams, etc., which can affect the strength and stability of apartment or building, or shall include any of the following. They mention these are all what is that called as a defect. And because it says that structural defect, there is nowhere in the RERA which has a definition of what you mean by structural defect. So Haryana has gone to the one more step more to say that what is structural defect. And on the screen, what you have seen is about the structural defect as per RERA. Why we are mentioning from various state practices, rules, or the notification are part of their agreement of sale, which gives some insight for us to appreciate and also understand the aspects of this defect liability, and also how this is viewed from various authorities and also the stakeholders in from the state to state. Next, we have something like the Tamil Nadu, which has mentioned in as part of their agreement sale itself, where it also mentioned that a normal wear and tear is excluded, and any willful or accidental damages caused is also, if anything damage happened due to the willful of the or accidental damages are excluded. Tampering by the allottees is excluded, and in case of the manufacturer provided some limited period, those things are also excluded, and also not included in terms of the airline crack. So let's summarize this and also look what Tamil Nadu RERA talks about. Normal wear and tear is exempted. If you see earlier slides of other states also, they say that normal wear and tear is exempted. We all agree with that, and also we should consider this. Result of any commission or omission of the allottee. If something is not handled properly by the allottee, and resulting into any damage, that cannot be considered as a defect under RERA. Okay, and of course, promoter may consider, and in order to keep the good relationship with the customer, they may attend to it, but that doesn't mean that it's a defect for the purpose of RERA. And next is, it's a good thing, any damages caused due to the acts of God or natural calamities. Friends, we know that something which happened, which is an act of God, like a tsunami, or it may be the earthquake or anything else, which has caused due to the act of God, and which results into some defect in the project building or the project, that cannot be the defect under RERA for the purpose of claiming the compensation or escalating it. Fire accidents, we all know that in case of a fire accidents, if something happens which has impact on the defect, which has impact on the project, that cannot be considered as a defect. However, if the precautions are not taken properly in terms of installation of the fire equipments or fire passages or fire exits, maybe one can consider, but it's all subjective. Case to case, one will consider, and also can approach the promoter for the same. And any willful or accidental damages caused which results into any defect cannot be called as a defect. So and any damage caused due to tampering by the allotee. So it's a very good thing that Tamil Nadu has come out specifically excluding what is not defect, what is not included for the purpose of RERA as a defect liability, and which gives some relief or some cushion or the comfort to the promoter when somebody raised the complaint or concerns stating that there is a defect. And also it says that Tamil Nadu RERA for the Tamil Nadu agreement for sale, further it goes and says that it only rectify once or repair above defect, and consequential damages will not be covered. Somebody repaired it, rectified it. If something happens subsequently after 5 years, those things again will not be covered. And also they clearly mention in case of a plastering, hairline crack is not at all covered as a structural defect. Hairline crack, we know that what is the reason of the hairline crack. It may be due to the curing issues, it may be the climatic condition issues. Invariably there would be a hairline crack. Those are not part of the defect liability. So this is specifically, these things are included in the Tamil Nadu RERA. And also finally, third party warranty and product shall be governed by the terms and conditions provided by the manufacturers of the respective products, which I already mentioned that in case of supply of any product, it may be including the mechanical items, it may be electrical item, it may be a plumbing item, it may be a tiles, it may be a paint, and anything which is covered by the manufacturer as a warranty, and the terms and conditions of that is considered for the purpose of defect, not for the just merely those things are supplied where promoter may not consider that as a defect and do the needful of repairing or replacement unless it is covered by the product. Example, as I mentioned, either the Philips or say OT's lift. Whatever the terms and standard terms and conditions of the OTs, that only be able to cover. Promoter cannot give something beyond what is manufacturer has given as the warranty or the guarantee for that. So these are all the things which is covered by various states in terms of what is not covered specifically, because if you read section 14.3 of RERA relating to the defect liability, it includes a mere reading of that says that all defects are included. And how do we say that something which is not included? Maybe these states have come out with some of the guidelines or by including in the agreement for sale. Those are the indicative, or those things are the some of the reference for any other states to consider while they represent or while they reply to the customers or the allottees in the project. Suhail, as Suhail mentioned,
Yes,
you want to say, yeah. So I just touch upon all the states. Yeah.
Yes, of course, by virtue of the rules, these states can do that because this will not be deemed to be against the act as such, because the act does not clearly stipulate what is to be considered as a defect and what is not. So by virtue of the rules in Telangana and also the inclusion of what is and what is not a defect under the sale agreement, so these two states have three states. In fact, I think Haryana has also done this. So otherwise, most of the other states have not defined or excluded defects as such. So it is open to interpretation. Of course, we have not had many litigations so far under this. Maybe in future, sometime far and few. Mostly, if at all anything is brought up as a defect, it would be for compensation, because it would amount to a dispute only when the promoter does not set right the defect which is brought to the promoter's notice. That is when the matter will reach the authority or the adjudicating officer for adjudication, either directing the promoter to set right the defect, or if it is before the AO, for compensation of that defect. So we have not reached that stage. Perhaps in future we will, but however, promoters should take care. And also, if it's if one of you is an allottee, then you have to make sure that you read through the specifications properly, you understand what is being offered to you, and then take it forward. So yes, these still these have not been, these either the amendments or these clarifications that are there in the rules and in the sale agreements, these have not been put to legal test, but we can take them as a general guidance in deciding what is a defect and what is not a defect. Yes, Vinay.
Yeah, thank you. Thank you, Suhil. So that will leads to some of the questions we should ask in terms of the project, in terms of like who will decide whether there is a defect which is due to structural design fault or the poor construction. This is one question. Who will decide is always, because somebody who file a complaint, generally an allottee or maybe association of allottees, and in case of any common area. So how do they decide, and who will decide? Say obviously, whoever file a complaint, the onus is on the person who file a complaint to prove that there is a defect, and defect is which is permitted under RERA and as per RERA, which is of a structural design. Say an example, we have a case where in plotted development, in a plotted development, as you all aware that the having completed the plotted development, all the roads, drainages, underground drainages, compound, electrical poles, transformers, and the overhead tank.
Vinay, sorry to interrupt. I have to quickly rush to the court.
Okay.
Okay.
Okay. Fine. Thank you. Thank you, Suhil.
Thank you so much.
Thank you, Suhil. Yeah. So in the case, what it is so happened that the allottees in the projects have not occupied the plots and not used the plotted development areas in common areas. After 3 years, a couple of customers have constructed their houses, and they observed that the tank, overhead tank, which is of a big structure where the strength is not sufficient, and which is of a poor in quality, which has resulted into leakage. Temporarily, something which has been done by the promoter. Promoter said only 2 people are there, where there is a 500 plots. Only for purpose of 2 people, I cannot like rectify this entire overhead tank. Maybe once there is a substantial people or substantial customer occupies this, then we can rectify it. By the time, I'm sure that generally we are aware that plotted development, unless which has within the vicinity, occupation is a challenge, and the structures or whatever be the defects which are all due to whatever be the reasons were unnoticed and which may not have a relief. And also as I mentioned that what should be the communication or reply by the promoter? Friends, as Suhel has mentioned out of his experience, first you accept whatever be the communication which is given by the allottee. And against that, please have your team to reply politely or appropriately, stating that by looking at what is a real concern about it, and whether it's due to the quality of the material or the workmanship or the because of the service deficiency. If really there is something which is to be considered by the promoter out of their mistake, out of their error, please do that. or if something which they found everything is correct, this is because of the wear and tear, or it may be the allottees mishandling. This is something which is the defect has been caused, so you can appropriately can be replayed to them, because one can make it out, whether it's purely the one customer problem or entire project problem. We have a case wherein in a project, out of 703 apartments in one phase, 703 in one phase, about 220 customers, allottees, have complained that there is a seepage in the walls. So how the seepage has come? Because of the some plumbing issues, related to the plumbing issues, the seepage has come. Obviously, promoter have considered that there is a problem in terms of the workmanship for the plumbing. They have undertaken to repair and repair the this plumbing line. Considering the 222 customers have complained and raised the concern about this defect. Obviously, you can make it out of 703, only 7 people have raised it. Maybe you can say that this is the something which is to be considered in independently. It may be due to wear and tear or mishandling. I'm sure that most of you have experienced in case of an apartment project. You hand over for the fit out, and during the fit out work, they alter various aspects. Common is the electrical lines they modify, or maybe in the bathroom if the chip out and do something plumbing line. So obviously, once they touch, I'm sure that most of you have a standard operating procedure. You will not consider any complaint which they raise it. If they do not touch, I'm sure that you can consider those things. But if they do anything relating to the electrical, plumbing, or mechanical during their fit out work, I'm sure that most of you don't entertain those complaints. So for that, you should have a proper procedure and communication stating that this is what. So in another case where we also experience, what I'm trying to say is all practical aspects. Practical aspects we encountered during our practice. Another best example is the slope, the level or a slope in the balcony area, where there's a balcony which is attached to the a living room. The balcony area slope is not proper, where water used to flow in the opposite direction rather than which goes through the whatever you call it as the where to the towards the pipe. So it comes inside the house through its door. So then out of 320 apartments, 40-50 apartments have this experience of slope correction requirement. So everybody has raised this concern, and ultimately the promoter has again taken the cognizance of this workmanship, where tiles are not laid properly, and they got it corrected. So it all depends on case to case basis, and one has to consider the communication. One has to verify how these really the defects are, whether those defects are due to the workmanship or quality. Friends, I am sure that at least we haven't received any complaint towards the structure of the building, like the roof or the walls. Of course, walls sometimes somebody comes, but it's very difficult for somebody to prove that that is the defect, because we know that having put the wall, there is a plastering, and maximum what can happen, only the crack. What type of crack? Hairline cracks are normal. If something crack is of a bigger size, then one will look into that. But we haven't come across anything related to the structure of the building, at least now, at least till now, in past 5 years. So if something which doesn't have a problem for the 5 years for the structure, I don't think there will be a problem in future also. However, we have received a quite number of complaints in respect to the electrical, in respect to the plumbing, in respect to some of these slope corrections which I told, and major complaints in terms of the tiles and the doors. Friends, I'll share a couple of examples of the tiles where the promoter has denied it because it's mishandled by a couple of allottees. that has led to the rejection of the claim by the promoter. Kids were playing inside the hall living area with a ball and a bat. Certainly, it has got damaged. The tiles are damaged. So when they raise a complaint and concern about the poor quality of the tiles, then the promoter has come to know that the kids were playing inside the hall with the bat and the ball. Obviously, that is not meant for it, and they rejected the claim of it. And somebody in terms of the doors, this is the one more case we have heard and also have undertaken. We all know this doors, na? Where in case of an apartment, there is a upper floor, there is a wind, there is a large wind. Unless these are doors are properly fitted and use the magnet, and obviously it's prone to the movement. Sometimes it hit hardly when the wind is there. So due to that, some damage happened. Obviously, those things may not be considered unless those are all not related to the material warranty guarantee by the suppliers. So these are all the various aspects which are generally encountered by the promoter of the project through the allottees. So what documents to state that it is a defect is important, and what documents you will call from the allottees in the project is also important. So please consider these things, and also let your team verify it whether it's a defect due to the inherent product quality or the workmanship. They can take a conscious decision on that. Finally, as I mentioned, whether the insurance has this structural defect insurance. Do we have this in India to providing that insurance? Maybe not many have, many are taking this insurance nowadays. Insurance has become the there cannot be a standard insurance. If you approach the insurance, certainly insurance can give this product to you, subject to calculating of what will be the premium they charge. Nowadays, the insurance product itself has become a tailor-made. Earlier, it used to be a standard insurance. Now, insurance also have become a tailor-made. Now, anything and everything insurance is possible nowadays, and certainly this can also be possible based on the requirement of the promoter. So how authority will consider and hear these complaints, or the adjudicating officer has mentioned that based on the detailed report of that. Certainly you just can't file a complaint stating that there is a defect in the wall and due to that there is a crack, I need a compensation of 1 lakh rupees. Or maybe tiles are broken in my house, which is 1000 square feet, 55 rupees is the square feet which is promised. I need 55,000 rupees as a compensation. Merely by filing those complaints, one will not get the compensation. They have to prove scientifically there is a defect, and due to the defect, there is a due to the defect of the material or the labor or the workmanship or the provision of, they have a loss to it, and that need a compensation. Who can give that report? Maybe a structural engineer or maybe an architect can consider this defect and can give a report on that. That would be the one way to look at that. So how the compensation, again, it's a compensation is a subjective. So adjudicating authority will consider this, and here, and if at all it require a compensation to be awarded, that would be awarded by the adjudicating officer. So finally, what we would like to say that, like, it is not something which is of a standard. It is unique to every project and unique to the promoter and unique to every allottees in the project. But what is standard is the 5 years from date of possession being handed over by the promoter, and this is what is the common to everyone. And please ensure that, to my knowledge, one need not to deny about it. Nowadays, this has become one of the marketing tool for somebody to say that I give 5 years defect liability for you. I give a 5 years of warranty, which is mandated under RERA also. We have seen this as one of the tool for marketing. Somebody say It's a RERA registered project. It's a tool for marketing. Being RERA registered project, there is a 5 years of warranty for you. It's a tool for somebody to market. So please take this as a positive, because there is no, you can't avoid this. Okay, having registered with RERA, you cannot escape for that. So at least make it as a point, as a marketing tool for the promoter to say that it's covered as a defect liabilities as under RERA. We give the 5 years of it, subject to so on so. So this itself will give some confidence on the allottees to consider that. So some of the best practices which are, we always say that, like as I mentioned, that 5 years of warranty from the date of possession means actually from the date of supply it may be 7 years or 8 years also. That is a difference. Like it's not exactly 5 years when you hand over. That is not installed that point of time. Somebody may be installed a year back or 2 years back from the date of from the handover of a possession. So accordingly, promoters should have the practice of having communicated with our suppliers and have some coverage to be made mandatory when you opt for the suppliers. Obviously, we have come across various project promoters, or we also recommending the promoters to consider these RERA warranty classes and provide their pricing accordingly. And as I mentioned, AMCs are separate, and as you all know that promoters clearly mention that any of the equipments, if that doesn't have a AMC, doesn't cover the risk of defects. So example, lift, generator should have a continuous AMC by the association or the allottees. And as I mentioned, this may have some impact on the finance. I don't say that there is no impact on the finance. Some impact, very small, like 100 rupees per square feet would be the some impact. We have made some study out of this defect level, how it impacted the entire project. There would be about 80 to 100 rupees per square feet would be an impact. Overall, if you consider 3 to 4 from the initiation to the completion of the project. And as I mentioned, then in terms of handing over, there should be a proper handover process so that there should not be any consequent claims from the allottees. So we also mentioned many a time to the promoter. See, here is the electrical fittings. You know that you purchase it, and each electrical fitting come with warranty period. You hand over those warranty card to the allottees itself along with the handing over letter. Here is a MCV. Here is a Jaguar taps. So I'm sure that most of this comes with the warranty period. You can hand over those copies to them. You can contact directly the vendor of those things and they will rectify it, because this comes with the warranty or the guarantee accordingly. And in terms of the legal team to observe is how the handover process and the documentation required for that, which will protect, which will mitigate the subsequent complaint or the concerns by the allottees. And how do you check, how do you supervise? Obviously most of the promoter follow this, but having said, they may require a little more process driven in terms of the handing over from the contractors to the promoters. Finally, the technical audits could be carried out throughout the construction period and even after construction period, to check whether things are in place. I'm sure that most of you may have a PMC or maybe external agency to do this audit. If you do not have, it doesn't cost much nowadays, and because there are various teams to come and do the standard verification, standard check. So that gives some advantage for the promoter in case of any subcontract, any in terms of any, if they give the contract as the entire project. As I mentioned that there would be an impact on this financial impact, please do consider that. So where do I consider? Maybe you can put as part of your estimated cost as part of your defect liability. You have various other costs are associated with that. Maybe cost of defect liability also you can put about 100 rupees per square feet as an extra as part of, which will allow you to withdraw from the project bank account. So that's all about the defect liability. If any of you have any specific questions relating to that, I can take up those questions. Open the open to audience, open to participants in terms of any of the questions.
So friends, I would request all the participants, if you have any queries regarding this specific topic, you can put up your questions, or you can unmute yourself and you can ask questions yourself. Again, I would request participants, if you have any queries, you can ask your questions right now, or you can mail it to us. Okay, I think we have got one message from one of the participant, that is there any decision on the RERA on this specific? Is there any decisions of the RERA on this? Sir, can you please answer this question? This is
Okay.
one of, yeah.
See, as I mentioned that we have represented the cases, and there are decisions, okay, and which is of the individual in nature, not of the as a project as a whole. And as I told you, the couple of cases of the plumbing lines, about 220 apartments out of 703 has a problem, is the one case we have represented. And also slope correction in the balcony is another case which also I have mentioned. Over a tank in a plotted development I have mentioned. These are all the practical cases we have addressed and we have represented. And of course, there is a fair outcome out of this also. And a couple of other cases wherein there is no ground for the allottees to say that, which I mentioned, the tiles damages because of the kids playing inside the home, and also the doors, the locks which were used of substandard. Of course, the promoter has clearly mentioned this is the brand I use it, and this is a cost price I use it. And subsequently, they found that it is not working properly. Promoter clearly mentioned that this is what I have promised and I used it. So authority also declined to give any specific relief to the allottees, stating that whatever be the agreement for sale, whatever be the information, whatever be the commitment which has mentioned in the agreement for sale has been delivered, and one cannot ask beyond that. That is what is the cases which are decided by RERA from time to time. Any other question, Shweta?
No, sir. As of now, no questions. But I would request the participants, if they have any query or questions regarding, I think, yeah, we have got one question again.
Okay.
Yeah, so one question from the participant is, how compensation can be calculated?
Okay, as I mentioned, friends, there is no specific way to calculate this compensation. When allot is, as we mentioned, allot is only file a complaint, and based on the technical report he submit, based on that, whatever be the cost of that defect would be directed to reimburse, plus about 5 to 10,000 rupees towards the legal cost of that. If at all, if the adjudicating officer is of the is convinced that there is a defect and the defect should be addressed. So that is how the compensation would be calculated under RERA for the defect liability.
Okay, so any other questions from the participants? They can send message directly to me or to the group. I think, sir, one participant have asked the questions like lifts, etc. be convert in the defect liabilities.
Friends, as I mentioned that something these lifts are the equipments which comes with the manufacturer warranty, and as long as those manufacturer warranty are covered clearly and the association continue to have the AMC, there should not be any impact and impact of the same. And for your information, again, we have represented the group where there is a insufficiency of the lift capacity. It is basically a defect flaw at the initial stage itself, where this is about 144 apartments, luxury apartments, and they have given two lift, passenger lift and one service lift. And this group has calculated technically stating that two lifts, passenger lifts, are insufficient for 144 luxury apartments with the 18 floors. And the promoter said this is what we have given as a standard. Then it has been represented such a way that this is a minimum standard that is provided, not which is to for the purpose to say it's a luxury apartment, because you have sold it as a luxury and you provided the minimum standard lift, capacity lift. Finally, we could say that allottees were able to prove that what they provided is a insufficient. I don't call it as a defect, it's an insufficient capacity, and which also finally has landed up with stating that's a defect in the plan itself, planning to provide the facility or amenity. So that is something which I can bring it here as a lift. And finally, they have got replaced the entire lift. Imagine they have replaced the lift itself would cost how much for a promoter? Okay, that is what I can see one of the case for a lift. Yeah, Shweta. Shweta, if you do not have any further questions, we can wind up the session. And there is a mail ID which is on the screen. If somebody still have any question, they can come back to ask the organizers. Friends, thank you. Thank you for being here in this evening for this session. Thank you, Shweta, for the
Thank you, sir.
continuous hosting of the program. Thank you.
Okay, thank you, sir. So at last, I would like to inform you all that our participants, that if you have any opinion or like any suggestions on the upcoming session topics also, so you can mail it to us to the like this email ID, sales@reraconsultants.in or rerapromo@reraconsultants.in. Friends, we welcome your suggestions and opinions on the particular topics of the session. So accordingly, we will take up and we would like to use the session on the shared topics. As of now, have a great evening, and thank you, Vinay sir, and thank you, Suhail sir, for your valuable time. Thank you. Thank you all.
Thank you very much. Thank you.